Hi, my name is Ethan Buckhalter, and I'm a student at Osgoode Hall Law School in Toronto, Ontario. In this episode of Case Law Minutes, we're going to be taking a look at the Supreme Court Canada case White Burgess, Langille, Inman versus Abbott and Haliburton Co. This is ultimately a case principally to do with the judicial regime surrounding expert evidence, where the law of the admissibility of expert opinion evidence has been further refined. A quick disclaimer. This video is for informational purposes only. If you do have a legal problem, it's always a good idea to talk to a lawyer who can give it advice pertaining to your specific circumstances. Now for the facts of the case. This is an appeal at the Supreme Court that stems from a case of professional negligence brought by the respondents, referred to here as the shareholders, against the appellants, who are the former auditors of their company. The shareholders initiated legal action subsequent to engaging a different accounting firm, specifically the Kentville office of Grant Thornton, to undertake various accounting tasks. It was at this point, according to shareholders, that the work performed by Grant Thornton revealed a number of deficiencies in the auditor's prior work. The primary allegation in the lawsuit thus asserts that the auditor's failure to adhere to generally accepted auditing and accounting standards during the execution of their responsibilities led to the financial loss of the shareholders. At the crux of this case thus lies the question of whether the auditors were negligent in fulfilling their professional obligations, but that's not what we're focusing on here today. In August of 2010, the auditors filed a motion for summary judgment, aiming to have the shareholders' lawsuit dismissed, and this is really where we want to focus on. In response, the shareholders engaged Susan McMillan, a forensic accountant, partner at the Halifax office of Grant Thornton. Her job was to thoroughly review all pertinent documents, including those submitted in the lawsuit, as well as to compile an expert report detailing her findings. In her affidavit submitted to court, she outlined her conclusions and asserted that the auditors had failed to fulfill their professional obligations to the shareholders. The auditors then sought to have Ms. McMillan's affidavit invalidated, arguing that she lacked impartiality as an expert witness. And this is an issue that we're going to look on at depth in further slides. They contended that the case essentially boiled down to a disagreement between two accounting firms, the auditors on the one hand and the expert witnesses on the other. The auditors argued that since Ms. McMillan's firm could potentially face liability if the court didn't accept their approach, and as a partner, Ms. McMillan herself could be personally liable, that she had a personal financial stake in the litigation's outcome, and thus made her have a conflict of interest and should disqualify her from testifying, and then ask the court to dismiss her affidavit. The main interest of this case, and the reason we're putting on this video today, is to clarify the legal framework surrounding the use of expert evidence in court. Now, it's important to understand that at first crack at the motions court, the Nova Scotia Supreme Court, and specifically Justice Pickup, agreed with the former auditor's contention that Ms. McMillan was not impartial and struck out her affidavit. However, upon appeal to the Nova Scotia Court of Appeal, a majority of the court found that Justice Pickup had actually erred in finding that Ms. McMillan's affidavit was inadmissible. According to Justice Beveridge, the court could have adopted the wrong legal test. The test used was that experts must be seen to be independent and impartial, which, according to the court, was incorrect at law. The Supreme Court really sought to clarify two issues. The first being that should the elements of an expert's duty to the court go to the admissibility of evidence rather than simply to its weight? Or two, is there a threshold admissibility requirement as it relates to independence and impartiality? Now, these two issues essentially boil down to the following. First, the court wants to clarify the law and test figuring out if an expert's evidence is admissible. Plus, they wanted to further clarify where the duty and role of an expert and the analysis within that falls into the test, which we're going to see on the next slide. So the Supreme Court of Canada clarifies that the role and duty of expert witnesses is extremely important in the context of admissibility. They discuss how expert witnesses have a duty to the court to give fair, objective, and nonpartisan opinion evidence. In doing so, the SCC sets out to convey where and how the expert's duty fits into the broader analytical framework surrounding the admissibility of expert opinions. So first they look at impartiality, and they say the expert's opinion must be impartial in the sense that it reflects an objective assessment of the question at hand. They also clarify that the role and duty of an expert witness involves independence, saying it must be independent in the sense that it is the product of the expert's independent judgment, uninfluenced by who has retained him or her or the outcome of the litigation. Next, they discuss how experts must be unbiased, saying it must be unbiased in the sense that it does not unfairly favor one party's opinion or position over another. The acid test is whether the expert's opinion would not change regardless of which party retained him or her. They further clarify that a proposed expert witness who is unable or unwilling to comply with this duty is not qualified to give expert opinion evidence and should not be permitted to do so. Less fundamental concerns about an expert's independence and impartiality should be taken into account in the broader overall weighing of the costs and benefits of receiving the evidence. So the admissibility of expert opinion evidence and the legal test that has been approached to the admissibility has been clarified in a number of cases, most notably in R.V. Abbey. The SCC adopted the two-step legal approach in R.V. Abbey, but added a few minor modifications, producing an exhaustive framework to assess the admissibility of expert evidence. The test that going forward is stage 1, the threshold test. The threshold stage, the party adducing the evidence must establish the requirements of admissibility. The considerations at this point are the Mohan principles emerging from R.V. Mohan. The first principle is relevance, so there must be a logical relevance to the case and facts at hand. 2, there has to be necessity. Is the evidence of the expert necessary to ensure the dangers associated with the expert evidence are not lightly tolerated? 3, there must be an absence of an exclusionary rule. And 4, their expert evidence has to be submitted by a qualified expert. Now, this is really where the Supreme Court's analysis is dug into and where the modifications to the existing Abbey test is made. Here, Justice Cromwell decides that the concerns related to an expert's role and duty, i.e., impartiality, independence, and bias, should be addressed at this stage of the threshold analysis. And in doing so, adjust the Mohan principles to include impartiality as subsumed within the threshold requirement for the admissibility of expert evidence. And this can be seen when Justice Cromwell says, "In my view, expert witnesses have a duty to the court to give fair, objective, and nonpartisan opinions. They must be aware of this duty and able and willing to carry it out. And if they do not meet this threshold requirement, their evidence should not be admitted." So this is subsumed within the threshold stage of the test for admissibility and is also a consideration when we come to stage 2. So the admissibility of expert opinion evidence test has a stage 2, which is ultimately discussed as the gatekeeping function. It's at this point that after the threshold requirement has been met, the court applies the discretionary gatekeeping rule or cost-benefit function. At this point, the court is supposed to weigh the potential risks and benefits of admitting evidence in order to determine whether the potential benefits of testimony justifies the risks involved in admitting the expert opinion evidence in the first place. So to look back at the first question as where does independence and impartiality come into the test, not only does the Supreme Court subsume impartiality and independence within the threshold requirement in stage 1, but they also say that as part of the broader discussion over the cost and benefit function of the gatekeeping role of the court, that they must also consider impartiality concerns at this stage as well. So if we look back to the original issues that we have started with, the Supreme Court of Canada focused on 2 questions. And in response to question 1, they respond in the affirmative. They say, yes, the expert's duties should go to admissibility and weight of the expert evidence. Ultimately, they also answer in the affirmative to issue 2. They say, yes, independence and impartiality are to be assessed at the qualified expert stage of the threshold test, as well as during the gatekeeping discretionary analysis by the trial judge. So after we've now gone over the 2-stage test that the court has to use when deciding whether expert evidence is admissible, we might as well circle back to White Burgess v. Abbott and apply what we've learned from the SCC's framework to the case at hand. Ultimately, the SCC applies this test and finds that Ms. McMillan's evidence was admissible, dismissing the appeal and finding that the motion judge had made a palpable and overriding error in excluding her evidence at the summary judgment stage. The court rules that there were no findings to ground Justice Pickup's ruling that the expert witness, Ms. McMillan, was biased or could be seen as an advocate for the shareholders who retained her firm. Instead, they find that she was aware of the standards and guidelines that experts need to be independent and was aware of her duty and precise regulations in the accounting industry concerning acting as an expert witness. Now, this is important, and there are a few final thoughts. Ultimately, the Supreme Court emphasizes the enhanced gatekeeper function of the second stage of the test, where the trial judge is really seen as an agent of change and warns the trial judge to be vigilant when weighing the admissibility of expert evidence. The SCC also holds that past business relations between a litigant and a proposed expert does not automatically mean that that expert is biased. And ultimately, looking past White Burgess, we now have a blueprint for how the admissibility of expert evidence should be approached, and specifically where the expert's duty fits into the legal framework, finding that it is involved at both the threshold stage of the test as well as the policy element of the gatekeeping role of the court in ensuring the utmost and highest standards of admissibility for evidence is upheld in our justice system. You can find the case on Canley, where I have inserted a link to the presentation. That wraps up this episode of Case Law Minutes. I just wanted to thank you for paying attention and watching, and hope this helps.